So now I'm going to transfer this over to Brad Kruse, who's going to talk about certain bankruptcy aspects that pertain in the agricultural arena.
Thanks, Molly. Hi, I'm Brad Kruse, and I'm going to talk a little bit about bankruptcy implications, but also pre-bankruptcy stuff as well. So here goes. There's me, and let's talk a little bit about pre-bankruptcy considerations, or what I've called dealing with debtors in the shadow of bankruptcy. And this would encompass a distressed loan situation or a troubled loan situation, and some things to look at, even though they may not be in bankruptcy. Maybe a bankruptcy is being complicated or contemplated, but maybe they're not even thinking about bankruptcy yet. The loan is just stressed. In this situation, it's important that the bank evaluate its options and available remedies as quickly as possible, because if you've been in one of these things, they can go south pretty quickly. And the best way to do this is to promptly conduct a thorough due diligence review of the borrower's situation. And what this would mean, it would be review the loan documents that are in place. Has everything been properly executed by the parties? Are all the signatures obtained, or all the documents where they're supposed to be, everything properly dated? Sometimes you find some inconsistencies and problems. It's better to identify them and try to correct them at that point, rather than to let it get any further down the road. Review the Ucc filings. Is everything up to date? Was everything properly filed in the first place? Are all financial covenants and ratios in compliance? That's something to look at. And you want to obtain new tax searches and lien searches, judgment searches on the borrowers and guarantors to try to determine what that situation is. One of the most important things to do in a distressed situation, and as we'll cover a little bit in a bankruptcy situation, is the collateral secure? Is it where it's supposed to be? And one of the things that you need to do is try to conduct on-site audits and reviews of your collateral. I've had numerous situations where we've had maybe the collateral is a herd of cattle or pigs, and if you're not out there monitoring what's going on, that can deteriorate. The health of the livestock can deteriorate very quickly. A lot of times in a distressed situation, there'll be an inclination to maybe skimp on supplements and so forth, and things for the herd. And so you want to make sure that you're on top of that. And you also want to make sure that the grain is being, if you got grain as collateral, is it where it's supposed to be? If it's being sold by the debtor, is the bank's lien being honored, or is the debtor trying to move it somewhere else, hide it somewhere, or try to sell it at an elevator that doesn't recognize or isn't aware of the bank's security interests? So that's a very important situation to look at. You want to evaluate other secured creditors, and if so, what are the lien and security interest priorities there? You want to get copies of the borrower's current and historic balance sheets, incomes, statement of cash flows, in order to make a realistic determination on how the borrower's business is trending, and what the borrower's future abilities may be. So if the borrower's is not trending, borrower's financials are not trending too poorly, you can consider restructuring the loan, negotiating a loan modification, or possibly entering into a new loan arrangement. One caution about entering into an entirely new loan arrangement: if you enter into a new loan arrangement, any defaults of the borrower and any of the lender's rights under previous defaults are going to be terminated. So sometimes it's better to simply modify the existing loan documents and so forth. And one of the most common ways to do that is with a forbearance agreement. And I won't spend too much time on this in our next session. A week from today, Ben Bruner is going to spend some time talking about this. But forbearance agreements can be a very, very powerful and significant tool for banks in distressed loan situations. In contrast to simply amending the loan agreement or entering into a new loan transaction, the forbearance agreement keeps the borrower's default in place, and it provides additional leverage and consideration to the bank in exchange for the forbearance of its rights that stem from the borrower's default. So you keep the borrower's feet to the fire, you get some additional consideration for the forbearance. And some of the key elements that can be used in conjunction with a forbearance agreement include adding extra security interests and additional collateral, or to perfect previously granted security interests, and you can do that in the forbearance agreement. Some other terms that you can put in a forbearance agreement include the waiver of the automatic stay if the borrower eventually files for bankruptcy, so that you can proceed against the collateral. You get potential release of lender liability claims that can be helpful. And some of the most important things to put to have in a forbearance agreement are simply the borrower's acknowledgement of the debt, the borrower's acknowledgement that they're in default, the borrower's acknowledgement that they don't have any claims against the lender, and so forth. And so I would strongly urge the use of a forbearance agreement, because it can have a good impact, and it can minimize the impact of a subsequent bankruptcy filing. Now, let's say all despite your best efforts to work out a satisfactory either refinancing or workout, and despite the fact that maybe you've even entered into a really nice forbearance agreement where you forbeared for the bank's decided to forbear its right to proceed promptly against the collateral. You gave the debtor some breathing room, but they still went ahead and they filed for bankruptcy. So now what do you do? And the most important thing to keep in mind is don't give up, and don't feel that all is lost, because there are a number of very powerful creditor remedies in bankruptcy, in a bankruptcy case, that are available to creditors, especially to secured creditors. Some of the first things, well, actually, let me talk just a little bit about overview of the various chapters. Chapter 12, of course, is the is applicable to a family farmer bankruptcy. It's sort of a hybrid between a Chapter 11, which is standard business reorganization, although Chapter 11 is open to individuals as well. So you might see a farm Chapter 11 case. Chapter 13 is sort of an individual wage earner bankruptcy, where the debtor commits a certain amount of its monthly income to a plan over time. And so Chapter 12 is fairly close to a 13 in that regard, but it's got some broader aspects that are closer to Chapter 11. The key to a Chapter 12 is that or some of the keys are that the debtor's got a limit on debts of $4,153,000. So if the debtor's trying to discharge or work through more debt than that, Chapter 12 is not going to be available. And it's only available if 50% of the gross income of the debtor is from farming operations. The time frame on a Chapter 12 is that a plan must be filed by the debtor within 90 days. The secured creditors must receive the fair market value of their collateral in the plan. There is an ability in Chapter 12 to file multiple amended plans, and in doing so can potentially extend the time of a Chapter 12 or the duration of a Chapter 12 case for a number of months, maybe even up to a year or over a year. I've seen those go as long as the court believes that the debtor is making some progress towards a plan. Chapter 11 is very similar, a little more time frame in terms of filing plans of reorganization there, and so those could potentially take even longer. But some very important things to do at the start of a bankruptcy case. You've got to stop collection activity because of the automatic stay on the old debt. But you should continue to do and conduct due diligence. And part of this is thoroughly reviewing the debtor's schedules and statement of financial affairs. There's going to be a plethora of information that's in those that's required to be filed in conjunction with the bankruptcy. And you're going to get a lot of that information on their assets, their income, and what drove them to bankruptcy, financial transactions that they've made over the past few years. All that's going to be provided in the schedule of financial affairs. And many times, what they've provided may be different and somewhat conflicting with what they've provided the bank, in terms of personal financial statements and financial information before. And if that's the case, if what they've provided the bankruptcy court doesn't match up what they've provided you in the past, there's the ability to take some action, and if it's material and it's to the level of really like a significant misrepresentation of their assets or hiding of transactions they engaged in, and they haven't told the bankruptcy court about it, they could be in the territory of getting their bankruptcy dismissed. So that's very important to take a look at that. Again, take a look at where the collateral is, and make sure the collateral is secure, or your collateral is secure and where you think it should be. If it's not, you have the ability to take immediate action with the bankruptcy court to lift the automatic stay and go after your collateral. Just because the bankruptcy is filed doesn't necessarily mean that the debtor is going to protect your collateral, so it's important to continue to monitor it. Talk about some of the big, moving on, let's talk about some of the big remedies that are available. We just mentioned relief from the automatic stay, which is a motion that's made to allow the creditor to proceed against the debtor because they're not protected. One of the main remedies to use at the start of a case is an objection to the debtor's use of cash collateral. And that's going to be prevalent in a Chapter 12 case or a Chapter 11 case. The debtor has to have the bank's permission to use the bank's cash collateral. And what do I mean by cash collateral? That is cash, accounts receivable, and inventory that's on hand. And for the debtor to use that, they either have to have the bank's consent, or the debtor has to have gone through the bankruptcy court to get authority to do that. And if it looks like the bank's collateral is going to be dissipated throughout the course of the bankruptcy, or is currently being dissipated, the bank can object to the debtor's use of cash collateral on the grounds that it's not adequately protected, which essentially means the bank is going in and saying, listen, we're going to be worse off here if we let the debtor continue to use our cash collateral. It's just going to waste the cash collateral, and it's going to be gone. So I'm going to move on. We've talked about the automatic stay a little bit. I'm going to move on to fraudulent conveyances here. Fraudulent conveyances are a possible avenue of recovery for the bank. If you can either proceed under Bankruptcy Code Section 548 or Iowa Code Section 684. So Iowa Code Section 684 has a longer reach-back period, and this can be a very powerful remedy for creditors, especially secured creditors, if the debtor has sold or conveyed or transferred assets without fair fair market value consideration. Another remedy that the bank has is to object to the debtor's claim of exemptions. Bankruptcy Code Section 522 provides a bunch of exemptions. Iowa Code also has a list of exemptions which apply to debtors, and oftentimes the debtors will be very liberal with the exemptions that they claim, and claim exemptions above and beyond what is provided in the Bankruptcy Code and above and beyond what's provided in the Iowa Code. And it's very important that the bank, if it's aware of that situation and it affects the bank's collateral, to go and object to the exemption, because in that situation, even though the debtor may have claimed an exemption beyond what's provided by law, the Bankruptcy Code provides that if no objection is filed by a creditor, the debtor essentially gets to keep the exemption claim. So it's important to go in and be vigilant and object to the claim of exemptions. Set off, another powerful remedy for creditors. It's most commonly used in this situation with banks where you've got deposit accounts that are held, and the debtors maybe not making the loan payments that they're required to make, and most loan documentation provides the bank with the ability to either sweep the account or offset the account, even if your loan documentation doesn't necessarily provide it or doesn't provide clearly for it. It is a common law right that exists in virtually every state to exercise your set-off rights. The key component there to remember is if you want to exercise your set-off rights after the debtor has filed bankruptcy, you need court approval to do that. You can't just go in and sweep the account after the bankruptcy's been filed. That would be an automatic stay violation. It could cause all sorts of problems for the debtor and have all sorts of contingent problems, and so you have to get court approval first. If the exercise of set-off isn't likely to hurt the debtor, the court's likely to grant it. If a bankruptcy hasn't been filed, you've certainly got the option to exercise set-off rights without any kind of court approval whatsoever. The only caveat there is if you have a reason to believe that the debtor's bankruptcy filing is going to be imminent, and you exercise your set-off rights and you improve your position vis-a-vis other creditors, it's possible that the exercising of the set-off rights in that situation will be deemed a preference. My advice to people to banks in that situation, or any creditor in that situation, is typically to go ahead and exercise the set-off right under the premise that a bird in the hand is generally more valuable, and if the debtor does file bankruptcy within 90 days after that and there's a preference problem, it's better to have to possibly give money back at that point than to have foregone the opportunity to missed out on the ability to exercise set-off, because who knows, the debtor may move the funds somewhere else and you may not have that option. Next and last remedy is discharge and dischargeability. These are a couple of items that are very powerful as well. Section 523 of the Bankruptcy Code gives you the ability to object to the discharge of the debtor's debt to the bank in the event that the debtor obtained that debt through false pretenses, fraud, false misrepresentations, and so forth. A prime example of that is if the debtor provided financial statements and other financial information in writing that was inaccurate to induce the bank to enter the loan in the first place. And second of all, Section 727 is a broader objection. It's an objection to the debtor's discharge in general, not just an objection to the debtor's discharge of its debt owed to the specific creditor. It's an overall objection to the debtor's discharge that applies across the board, and that's in the event that the debtor engaged in some improper conduct, didn't comply with the bankruptcy code rules and formalities after the bankruptcy was in place, or hid assets or misrepresented anything on the bankruptcy schedules. A 727 objection is possible. As far as strategic considerations, I generally believe it's better to go under Section 523 rather than both. You see a lot of times where both is claimed, or both options are claimed. If you get the broader discharge under 727, that means, or object to the discharge under 727, that means that all creditors can come back against the debtor for the debts owed. If you merely go under 523, the debtor gets a broader discharge against all the other creditors except you. You're generally in a little bit better situation in that regard. So my time's just about up, so I'm just going to say, reiterate that it's very important to be diligent at the start of a bankruptcy case or the start of a troubled loan. Do your homework, and there's a lot of options available, both pre and post-bankruptcy filing, that can be very helpful and powerful to you. So that's the end of my talk. Next Tuesday, February 27th, we're going to have Jeff Baxter talking about essential provisions in loan documentation. Ben Bruner is going to talk about